Last week, the U.S. Supreme Court unanimously sided with a Catholic foster agency, Catholic Social Services, in its battle with the City of Philadelphia. So the City of Philadelphia had banned this Catholic foster agency from participating in its program because they excluded same-sex couples. So that's what we're going to be talking about today. It's the case of Fulton versus the City of Philadelphia. The City of Philadelphia, which is the city of brotherly love. I didn't mean anything by that. It's known as the city of brotherly love. It is. Okay. All right, just a little bit of background. So Philadelphia's foster care system, it relies on these private foster care agencies, and they have contracts with these companies. So when a child can't stay in a home for whatever reason, they contact one of these agencies and they're able to place the child in a foster home. One of these agencies is Catholic Social Services, or CSS, as it's referred to in this case. And CSS has been working with the City of Philadelphia, I believe it's for 50 years, and everything has been peachy and great, up until just recently. Now, Catholic Social Services, or CSS, they hold the belief that marriage is between a man and a woman. So when they go to place a child in a home, they will not place the child in a home with a same-sex couple. So they won't certify a same-sex couple for a foster care situation. But there are other private foster agencies in Philadelphia that will certify same-sex couples. So in practice, if a same-sex couple would have come to CSS, they would have referred them to one of these other agencies. And I believe there were 20 other agencies in Philadelphia besides CSS. Now, you would think that this started when a same-sex couple came to Catholic Social Services and they wanted to be foster parents. That is not what happened. According to the records that I've seen, there has never been a same-sex couple in Philadelphia that went to CSS and wanted to be foster parents. That hadn't happened. So what did happen? The media happened. That's what happened. In 2018, one of the newspapers up there decided to cause trouble. That's what happened. So in 2018, a newspaper came out with an article saying, hey, did you guys know that CSS excludes same-sex couples from their foster care program? And then Philadelphia canceled their contract with CSS, the one that had been in place for like 50 years. They immediately canceled it because of that story. So just one other thing about the city of brotherly love thing with Philadelphia. Like, that's the Greek translation of Philadelphia. Like, Philos is brother, Adelphos is love. So it really translates from the Greek, like the city of brotherly love. I'm not making this up. Like, this is not, don't make this into a thing. That's what the Greek translation is. All right, so then the lawsuit was filed. Catholic Social Services and 3 foster parents sued the City of Philadelphia. Again, the case name is Fulton v. City of Philadelphia. And they were going for an injunction and arguing that the City of Philadelphia was violating their freedom of speech and free exercise rights under the First Amendment. So what happened at the district court? Actually, CSS and the foster parents lost. The City of Philadelphia won at the district court. Went up to the Third Circuit, and a 3-judge panel of the Third Circuit, they all agreed that with the City of Philadelphia that they could do that. And so CSS and the foster parents lost at the Third Circuit. Then we went up to the Supreme Court, which is how we got this decision that we are talking about today. So now let's talk about the Supreme Court decision. I will try to not get too far off in the weeds because I know you'll stop watching. You may have already. If you're still there, thank you. So last week, a unanimous decision from the United States Supreme Court. 9 justices agreed with the decision here that what the City of Philadelphia was doing could not survive strict scrutiny and violated the First Amendment. So let's get into that. Chief Justice Roberts wrote the majority opinion. Here is one quote from the opinion. CSS, which is Catholic Social Services, seeks only an accommodation that will allow it to continue serving the children of Philadelphia in a manner consistent with its religious beliefs. It does not seek to impose those beliefs on anyone else. The refusal of Philadelphia to contract with CSS for the provision of foster care services unless it agrees to certify same-sex couples as foster parents cannot survive strict scrutiny and violates the First Amendment. That one line, I'm wondering if there's some subtext to this when Chief Justice Roberts says about CSS, it does not seek to impose those beliefs on anyone else. Don't you feel like the next line is kind of, but you are, and that's wrong? I mean, I don't know, that the words, it just seems like what he's saying is, they're not trying to impose their beliefs on anyone else, like you guys are. And that's, you can't do that. So there's another case, a Smith case, that talks about the free exercise clause and whether strict scrutiny should be applied or not. And basically the Smith case says that if you have these laws that are applied and they're applied generally and neutral, then you don't have to apply strict scrutiny to this free exercise clause situation. And part of the discussion here was whether Smith applied in this case. And the Supreme Court said Smith did not apply because what Philadelphia was doing was not general and neutral. All right, so here's why what Philadelphia was doing was not neutral and generally applicable. So in their contract with these foster care agencies, there was a section that said that when contracting with parents, they couldn't do it based on their sexual orientation. But the same section also had an exemption in it. They said that it permitted exceptions to this requirement at the sole discretion of the commissioner. So that's why it wasn't neutral and generally applicable, because the city of Philadelphia could just decide on a case-by-case basis, oh, you don't actually have to do that. You don't either. Are you guys Catholic? You do. I mean, whatever they were doing. But they had an exception, and that's why it wasn't neutral and generally applicable, and that's why it fell outside the scope of Smith. And why was it important to fall outside the scope of Smith? Well, if you're outside the scope of Smith, guess what? Strict scrutiny is going to be applied, and you are screwed, basically. But if they could fall under the guise of Smith, then arguably they may not have had strict scrutiny applied, and Philadelphia may have been able to get away with this. Which begs the question, is Philadelphia just going to get rid of this exception and then Smith applies? Okay, just one more thing on the city of Philadelphia being the city of brotherly love. I don't even know if that's a phrase that should be said anymore, because like brothers and I don't know. So it probably should be like the city of love between persons that came out of the same birthing person. That rolls off the tongue. Like, I don't know what the Greek is for that, but that's, somebody should check, because that could be a new city name. You're welcome. All right, thank you for watching. We'll see you next time.